Thank you, Taylor. I am delighted to be here. I am really happy to talk about technology and APIs and the law and how all these things intersect. So, this title, The Law of the API, this is not the title of my talk. This phrase is actually a reference to a famous to tech lawyers article from 1996 called Cyberspace and the Law of the Horse by Professor Frank Easterbrook. The point of that article is to contextualize emerging law as it relates to the internet, activity that took place online, the tools and places in which we interacted with each other. So Easterbrook's core thesis is still very much relevant today. We don't have a law on APIs, and the law isn't really meant to focus on specific technologies. Instead, the law governs activities by both people and businesses. But just as laws aren't built specifically for technologies, we don't build technologies specifically for laws. The result of that is that there's not a lot of collaboration between the people who build APIs and the people who shape laws. And from my perspective, as someone who sits in between these two worlds, that's a missed opportunity. I believe that when we design technologies and laws with a healthy understanding of each other, the outcome is a better ecosystem. So first and foremost, my goal today is to help close that knowledge gap a little bit and talk about some recent developments in the law, as well as some developments that are on the horizon that matter, I think, a lot to API development. Now, I've spent a lot of my career working with policymakers to help them understand technologies. And in fact, I've spent a lot of time over the past few years talking about APIs to policymakers, how they work and why they're important. So I'm really excited to talk to you about the law and approach this from the other side a little bit. And the law around APIs has been pretty interesting lately. The Supreme Court came out with a really major decision this year in the decade-old Oracle v. Google case, which I'm sure many of you have heard about the Java APIs. And trust me, I have a whole slide on that later. But the legal landscape is a lot richer than just that. So let me give a little baseline about me. Taylor, thank you for the wonderful introduction, but just so you know where I'm coming from. I'm not a developer. I walked away from computer science because I wanted to work more at this intersection of law and technology. That's what led me to law school. That reminds me of a disclaimer I want to make. None of the following is meant to be construed as legal advice. I've been an inactive member of the California Bar for nearly 8 years. So when I take a position on a court case or law, please bear that in mind. I'm not technically today a lawyer. Lawyers have very strict rules against false practice of law. So just wanted to get that out of the way. That said, I talk about the law a lot. And in fact, this particular provision in the law is part of why I went to law school. This is the Digital Millennium Copyright Act, or rather one clause in it. It was adopted in the United States in 1998. The risk of dating myself, that was before I graduated from college and started my doctoral program. The language in it is kind of technical. Interoperability, circumvent a technological measure, controls access. These are the kinds of terms technical experts can debate the interpretation of for days or weeks or longer. The DMCA was adopted during a pretty big time for intellectual development at the intersection of law and technology, late 90s, early 2000s. I spent that time period reading books by Larry Lessig and following developments like the founding of Creative Commons in 2002, if you saw the earlier talk by Mehdi about Creative Commons for APIs. You may also remember 2005, when the Supreme Court of the United States held unanimously that peer-to-peer file sharing network Grokster could be sued by copyright holders and held liable for the unauthorized transfer of copyright protected works by its users. So there's a pretty rich history here, and it's probably not surprising that it's copyright law that has led to one of the two big court cases at the intersection of APIs and the law that I want to talk about today. That case, of course, is this year's Supreme Court decision in Oracle v. Google. That's a Java cup, in case you were curious about the imagery. While likely the facts of this case are pretty well known, let me reprise it all just to make sure we're all on the same page. And it's possible that the common understanding in this case isn't entirely accurate. Before it was acquired by Google, long before actually, Sun Microsystems created Java as both a programming language and a set of libraries to make Java programming easier. Those libraries were documented through APIs, which included effectively computer code that specified how to make calls to the libraries. As a general rule, computer code is protected by copyright law. I'm stating that as a fact. I'm not taking a normative position. In my heart of hearts, there's still a part of me that wonders if that's the right way that it should be, but it is a fact. When Google developed the mobile Android operating system, it built its own Java libraries. And as part of that exercise, effectively copied this interstitial code, the code associated with the Java APIs. That copying made it a lot easier to achieve interoperability between programs that would run Oracle's Java libraries and Google's Java libraries. This case, the Oracle v. Google case that the Supreme Court decided, is at its heart a question of whether that general protection for copyright that computer code gets extends to this translational language around API code itself, the interface. And the Supreme Court did not answer that question. Instead, the court found that Google's use of the API code counted as fair use under copyright law. So at the end of the day, Google can't be held liable for copying the 11,000 lines of code associated with the APIs into Java libraries. So can we just copy APIs now? The standard joke about lawyers is that the answer to every question is it depends. Remember, I'm not legal advice, I'm not a lawyer, and I'm definitely not your lawyer. That aside, this image is of a koala in a eucalyptus tree. In addition to being cute, it's also a reference to eucalyptus, which is an independent implementation of the Amazon Web Services APIs. One thing about law is that it does not self-effectuate. Unlike code, it costs a lot of money to enforce law. You have to bring a lawsuit and it can take a very long time. The Oracle v. Google case, for example, took more than 10 years. It was originally filed in August of 2010, and the Supreme Court finally resolved it in April of 2011. As I said, ultimately, the copyrightability of APIs remains unresolved. Now, fair use is a very powerful tool, and it protects quite a lot of uses of copyright-protected code and other content. But to gain its benefits, you have to meet all four prongs of the four-part test. And in the context of APIs, I think there might be some variability in three of those four prongs: the purpose and character of the use, the amount of copyright-protected content, and the effect of the use, the fair use, or would-be fair use, on the market for the original protected good. But more than all those technical details, there's something that still feels kind of existential to me about all this. When you're re-implementing an API to make something interoperable, what really are you copying? Are you copying the language of the interface? What is it about the API that makes interoperability actually work? This is all a long way of saying, I'm not sure we're done with court cases around APIs and copyrightability, despite this really big Supreme Court case. But enough about Oracle v. Google. I want to move on to my second case study. So this may be less obviously related to APIs, but please bear with me. The Supreme Court this year also released a decision in the case VanBuren versus United States. In case this is less well known to some of you, let me recap. A police officer, Mr. VanBuren, was set up in an FBI sting operation. He took some money to look at a database to which he had lawful access to determine whether a vehicle license plate was being used by an undercover cop. He was charged under the Computer Fraud and Abuse Act, CFAA, a 1986 law, sometimes known as the anti-hacking law, which was passed in part based on congressional legislator fears over the 1983 movie War Games. I'm not kidding about any of that history. The question before the Supreme Court was whether VanBuren could be held liable because his purpose for accessing that database was not lawful. He had lawful access to the database. He had lawful access to this particular information in this database. It was merely that the reason by which he was accessing this was not itself one of the reasons by which he could access it. And the Supreme Court concluded, in a nutshell, that Mr. VanBuren had lawful access and therefore was not liable under the anti-hacking law. So you may be wondering, how does this relate to APIs? There's some disagreement still about legal scholars about how this opinion will be used going forward. There's a famous footnote 8 that has some ambiguity into it. But my reading of the case, and I think it's generally the common typical reading of it right now, is that when you give someone access to information through an interface, such as an API, if they use that information for purposes you didn't have in mind, they aren't considered to be hacking under the auspices of this law. I go through this mostly to illustrate that as interesting as copyright is in the context of APIs, the legal backdrop overall is far more complex than just that. There are security issues in place sometimes, and I haven't talked about privacy and data protection law at all. I could spend the entirety of my talk talking about that, but those of you working in corporate environments have probably already heard from your lawyers about Europe's GDPR, the General Data Protection Regulation, and that's a rabbit hole that I'm just not going to go down today. So instead, I'm going to shift gears a little bit and look to the future, to where I see conversations around competition law going, and in particular to interoperability, a topic for which APIs are obviously extremely relevant. Interoperability is a rapidly growing area of interest to competition regulators and legislators. As I said earlier, I've spent a lot of time in these conversations myself. So when I was at Mozilla, we submitted a fairly substantial filing to the Federal Trade Commission in August of 2018. So the title of Section 3 of that comment, I looked it up just to make sure that I could say this correctly, was, quote, interoperability is a powerful, ready-to-use key to unlock competition in the tech sector, end quote. So we are trying to bring home here that all of these conversations around competition, they're focused on mergers, they're focused on the size of companies. We really wanted to make sure interoperability was understood as a part of that bigger picture. So in that section of our filing, we talked a lot about APIs. We talked about what happens when a platform shuts down its APIs, and it locks down its APIs, on which other services have grown to be reliant. And 2018 was actually a pretty big year for that because there were some fairly major changes to some major services APIs that were throwing off a lot of independent or indie web development at the time. I like to think that at Mozilla, we had some influence there because when the FTC ultimately filed its antitrust lawsuit against Facebook in 2020, their complaint heavily featured actions by Facebook to limit its own APIs. Ken Lane actually wrote a piece about this in December of last year, which I very much liked. I think this shows that the Federal Trade Commission reached a fairly advanced level of understanding in the nature of competition online. The other antitrust lawsuits, they didn't talk about that. They were really just focused on mergers. So I'm really proud of this work that a number of us have done, not just myself, to really help illustrate the importance of interoperability and APIs in how the internet really works today. The European Union, on the other side of the Atlantic, and this slide, also has what I would consider to be a fairly advanced level of understanding of competition in the tech sector. And certainly it's proposed the most aggressive intervention that I have seen from any government in the Digital Markets Act introduced last year. So I'm not taking a position on that, merely noting that it is a very strong law. And this transatlantic government interest reflects and follows on the heels of growing academic interest in interoperability as it relates to competition as well. There were three very major reports coming out of academic researchers in 2019, one in the United Kingdom, one in the European Union, and one in the United States. Not coincidentally, these came about a year and a half before major legislative developments in all three regions. And interoperability was not the majority of, but a major part in all of these activities. So that middle image is a screenshot of one of the more fun talks I've given. It was in January of this year. I was invited to speak specifically about APIs to the Digital Economics Conference at the famous Toulouse School of Economics in France. I was only sad that because it was COVID, I had to do it over Zoom and couldn't go there in person. So there's a lot of interest here in this topic. But let's pause it for a minute. I want to take a step back and look at the major evolutionary phases of communications technologies. None of this is news to any of you, but I think it's helpful context in thinking about interoperability. This is part of the pitch that I give to the policymakers and the lawyers as well. The important part of this history to me is that at each step of the evolutionary process, the edge, the service facing the user, becomes the new center, the new infrastructure on top of which new edge services are built. First, the telephone was the service, then it became the edge, the infrastructure on which the internet was built. First, the internet itself and its protocols were the service, think Telnet, FTP, then it became the infrastructure on which the World Wide Web was built. These days, the open web that we all grew up loving and exploring doesn't feel so much like the service anymore. It feels more and more often like infrastructure. We've built layers on top of layers, and the application layer of the OSI stack has become this complex cloud of interconnected services. As a place where new services are built and reach end users, the open web is competing with mobile in particular. I would say the new edge is defined by apps and APIs because that's what you build to reach new end users these days. And to me, the consequence of that is a challenge to some of our long-held assumptions that the internet will be effectively interoperable. It's not for nothing that a lot of commentators on the current state of tech compare the modern internet environment to classic historical walled gardens. And that threshold, the threshold by which interoperability is evaluated in practice, the reason why we're seeing this and saying we see walled gardens here is usually APIs and the policies associated with them. It's this combination of things, an evolution towards apps and APIs, and a growing concern that we're building modern day walled gardens as a result, which is why the academics and the regulators are so interested in interoperability and in APIs these days. So what's the takeaway from this? What does this all mean for the open API community? For me, Oracle v. Google means, in a nutshell, it's hard to use copyright to secure an API, no matter what license you choose for it. You can always get that fair use defense. Thanks to VanBuren, it's also harder to use the anti-hacking law to control access to data once it is made available, including through APIs. And combine those with the increasing attention from governments towards interoperability as a means of providing competitive opportunity. It feels like it's possible to me that things could really start to open up. However, good policy is not as clean as good code. It's messy, it's not well documented, the future is always uncertain, and it's influenced heavily by humans and by politics. I do feel like I see a trajectory, though, a sort of a bending of an arc toward openness. And frankly, I feel like the work being done by the open API community to build standardized descriptions and specifications is leading that broader arc along in a major way. Thank you. And there's a lot more here to drill into, so I look forward to questions.
Thank you so much for that. That was awesome. I don't know, just a little interesting tidbit of history is back in 2015, the conference that preceded the API specifications conference, API strategy and practice, we actually had Sarah Zhang, who was a popular reporter of the time around the case, come speak. And so it's been very interesting to us that kind of 6 years later, we're still talking about this thing, because you said it took 10 years. First question for me is just, how have you seen things change in those 10 years, even just from when, the start of the case to when, the actual decision had come down from the Supreme Court? I'm just kind of curious, like attitudes out in the world that you live in that many developers don't necessarily maybe see.
Yeah, well, it's a slow process of evolving broad understanding of these issues, and I won't claim that it has made a huge amount of traction. But I'll give you two examples, and neither of these is specifically on APIs, please forgive me. 15 years ago, I saw the word computer being used by policymakers as, I call it a synonym for magic, or even for black magic. So you hear the way computer is used, and it was this thing that policymakers don't understand, and they don't feel like they have control of. And so they have this strong fear reaction to it. That fortunately has changed. You don't see computer being used that way nowadays. More often these days, it is algorithms that you see being used as a sort of black magic. Unfortunately, or fortunately, I'm not sure which yet, not enough policymakers could tell you what an API is for that to have really yet entered the lexicon. So when you get to a case like Oracle v. Google, like on some sense, it's a good thing that it's in the courts where they can get expert reports and witnesses and really drill down on the technical details, and not something that is right yet in front of the legislature. Instead, we have the I guess, relatively more digestible concept of interoperability, as long as multi-syllabic of a world as that is, because it does have echoes into earlier forms of communication, earlier modes of competition and openness and so forth. They can think about interoperability, and they can think about how banks can communicate with each other and send transactions. They can think about worlds and spaces that they know. And so I think that we can make a little bit more headway on awareness by use of these references to earlier technologies and sort of values that we've built into them.
Yeah, that's interesting. So one of the questions from the audience is said, based on your last slide, what policy changes do you see on the horizon in the US and in the EU? That's a pretty broad question, but if you have specific ones that you would like to talk about.
I will give you a short answer to that. I gave a talk about 4 years ago at the Harvard Kennedy School of Government where I said, the future of tech policy for the next 10 years is CATS. CATS is an acronym because it always is. And this CATS is competition, algorithms or AI, tracking, and speech. Thus far, I think that set of issues has landed pretty well. Seen a lot of competition, a lot of tracking, a lot of privacy. So that's what I'm looking at. That's the horizon I'm looking at.
Yeah. The second question, do you think providing API specifications makes it easier to, quote, reverse engineer in a legal sense or harder?
It depends what you mean by easier. Like easier from are you more likely to be on legal sound footing if you are re-implementing an API that is well documented versus are you on stronger footing if you're re-implementing an API that is not documented? Probably I would guess it doesn't make
Yeah.
that much difference, and that you have a
Yeah.
fair bit of freedom under these laws as I discussed them in order to re-implement it, regardless of the level of documentation. I mean, practically, of course, it's much better if a specification is provided, because then you are sort of signaling what you want people to be able to do and not do. And it's a lot
Yeah.
easier for you to engage in sort of terms of use control and contractual control, and not risk running afoul of, I don't know, consumer protection laws in various ways if you set up reliance on one thing and then change it if it's not being documented. I can see the quickest legal hurdle for someone running an API to run into coming from the Federal Trade Commission. If you say one thing and then do another in practice, the FTC could go after you pretty quickly.
Yeah. A third question. What might be the impact of seeing a decoupling of organizations and the walled gardens they currently try to protect?
This is a very open-ended issue,
Yeah.
right? Let me pick a very relevant and timely
Yeah.
example, right? Which is the fight between Apple and Epic Games over app stores and app store fees, right? I think there was just a first round of court case in this. A federal district court judge. There are at least two rounds after that, and probably a long, long fight ahead. But what we saw was the court saying that Apple, under California's state competition law, while Apple is not considered a monopolist for this relevant market, under California competition law, Apple cannot tell Epic Games that they cannot tell their users how to buy virtual goods and currencies and services and so forth outside of Apple's platform. Lots of negatives, lots of contractual things. Forgive me for the complexity. But what we're seeing as a result of that is this real battle for power. Like, it's a real serious battle for power between Apple and Epic, and there are versions of this power battle happening all over the tech ecosystem. And the response that we've seen so far, the first wave of response was Apple kicked Fortnite out of the iOS store. So the short-term impact we're going to see is chaos. Let's put that right out there. The long-term impact, I hope, as we have more and more conversations about this, as we sort of collectively share a goal of a competitive market that sees honest returns on investment and innovation, and that sees interoperability being baked into the future of the internet, which I think is a value we can all stand behind. I think eventually we'll see good, well-rewarded services with good user experiences and lots of opportunities for downstream innovation. That's certainly what I'm pushing for.
Yeah. And then the last question, will DNS continue to influence the defense of API copyright because the interfaces are moving out of the code and onto the open web?
There's a lot of layers into this question, and I could probably talk about it for a very long time.
It's a very Ken Lane question because it is coming from Ken.
Excellent. Yeah, well, so this is, one of the messier histories of fights at the copyright tech and law intersection is the copyright rights holders industries trying to go after domain name holders to say, hey, this domain name is being used to host a bunch of content that is being made available without permission, copyright protected content, our content being made available without permission. So this actually unleashed a really powerful wave of activism in the United States in the SOPA-PIPA wars of a little less than a decade ago. So we're not done with that fight yet either, right? Just to jump to the end, we're not done with that fight. The domain name system is still governed by this complex multi-stakeholder ecosystem. The levers of power are always moving in the tech space, and around domain names, they're moving even more now than they have been in years past. So while we haven't heard about it in, I don't know, 12 months or so, maybe not since the controversy over .org, we're definitely not done with DNS being sought as a lever to be pulled to strengthen the exclusionary power of rights holders in this context.
Great. Thank you so much for joining us, Chris. Really appreciate it. It's brought a different insight to the conference that we normally have, and it's been super relevant and super interesting.
It's my pleasure. Thank you for having me.
Thanks.
Cheers, everyone.
Bye.